Centre for Public Legal Education Alberta, CPLE, is a non-profit organization with the goal of making the law understandable for Albertans. CPLE provides legal information and education to the public. Only lawyers can provide legal advice. Look for our contact information at the end of this video. Enjoy!
The Centre for Public Legal Education Alberta runs a residential tenancies legal information program, which provides legal information for landlords and tenants in Alberta. The program is funded by the Alberta Real Estate Foundation and has been going strong since 2000. You may be familiar with our Laws for Landlords and Tenants in Alberta website. We get many questions every year about renting, from both tenants and landlords throughout Alberta. We also keep track of popular search terms on our website, so we have a good idea of the types of issues or questions that tenants and landlords deal with frequently. This video is part 3 of a compilation of our top 10 housing law issues. We will be covering evictions, human rights, and dispute resolution. A tenant did not pay rent. The landlord served a 14-day notice. The tenant did not contact the landlord, did not pay, and did not move. In this type of situation, can the tenant be evicted? And on the termination date, can the landlord change the locks? For the first question, yes, the tenant can be evicted for not paying rent. Not paying rent is grounds for eviction under the RTA. On the other hand, the answer to the second question is no. A landlord cannot change the locks without providing the tenant with a key immediately. If the landlord locks the tenant out, the landlord has committed an offense under the RTA and could face a fine of up to $5,000. In a situation like this, the landlord should make an application for recovery of possession in court or through the RTDRS. Tenants must follow the 7 rules in the RTA. If a tenant fails to do any of these things, then the tenant has committed a substantial breach of the residential tenancy agreement. A tenant also commits a substantial breach by committing a series of breaches of the residential tenancy agreement if the total effect of all the breaches is substantial. So, for example, continuing to pay rent late each month for multiple months may be considered a substantial breach. If a tenant commits a substantial breach, the landlord can give the tenant a 14-day notice to terminate the tenancy, or give the tenant a 24-hour notice to terminate the tenancy for causing significant damage or assaulting and/or threatening to assault the landlord or another tenant, or apply to the Residential Tenancy Dispute Resolution Service or Provincial Court for an order terminating the tenancy. There are also special situations where a landlord can give a 24-hour notice to end a tenancy. For example, if the tenant has significantly damaged the rental property and/or physically assaulted or threatened to physically assault the landlord or another tenant. It's important to highlight that a tenant cannot object to a 24-hour notice. First, the tenant can go to our website and download the eviction notice poster. They can follow the flowchart to make sure that the eviction notice is valid. If a tenant is facing an eviction hearing and wants to fight the eviction, the tenant should seek legal advice. If the landlord serves the tenant with a 14-day eviction notice and the tenant does not agree with the notice or the notice is not valid, the tenant can usually serve a notice of objection on the landlord. The objection notice must be in writing and set out the reasons for objecting to the termination. It must be sent to the landlord before the termination date set out in the notice. A landlord cannot make a tenant move if a notice of objection is served before the termination date given in the notice. Once the landlord receives the objection, the tenancy remains in place. The landlord would have to apply to the Residential Tenancy Dispute Resolution Service or Provincial Court to end the tenancy. Another important thing to keep in mind with evictions is that tenants cannot object to eviction notices for unpaid rent. The only thing a tenant can do is pay all of the rent owing by the termination date in the notice. If rent is paid before the termination date, the eviction notice is considered void and the tenant can continue staying in the premises. If the landlord changes the locks on the tenant can call a locksmith to get the locks changed back. The landlord is not allowed to change locks without providing a key until the tenant moves out. As a tip, a tenant can file a complaint with Service Alberta if this happens. A tenant is a single parent with children and is looking for a place to rent. Can a landlord refuse to rent to the tenant because they think that the tenant's children may be too noisy? Or if the landlord has concerns about the tenant paying rent as a single parent? In this type of situation, the answer is no, because the landlord's refusal to rent to the tenant can be considered discrimination and a violation of human rights in housing. Let's take a closer look at what we mean by discrimination. Discrimination imposes burdens, obligations, or disadvantages on individuals, or limits their access to benefits or opportunities, basically treating a person differently based on protected grounds. The Alberta Human Rights Act protects tenants from discrimination on a number of protected grounds, for example, mental or physical disability, family status, race, religion, and gender. There is a legal duty for landlords and service providers to accommodate a person's needs based on the protected grounds to the point of undue hardship. If experiencing discrimination, a tenant can file a complaint with the Alberta Human Rights Commission. This is a complicated area of the law, so tenants and landlords should refer to the Alberta Human Rights Commission and their website for more information. Tenants and landlords can also check out 2 information sheets that CEPLI helped develop to learn more about the topic: Human Rights in Tenancy and Human Rights in Condominiums. If a landlord and tenant have a dispute, the first step is to communicate about the situation and try to work out a solution. If an agreement is reached, make sure it is in writing. But if a landlord and tenant cannot resolve a problem on their own, there are dispute resolution options available. 2 common methods of dispute resolution for residential tenancies matters under the RTA are the Residential Tenancy Dispute Resolution Service, also known as RTDRS, and Provincial Court. The RTDRS offers landlords and tenants an alternative means of resolving serious disputes outside of court. This service is designed to be faster, more informal, and less expensive than the courts. To file an application with the RTDRS, there is a $75 application fee. To file an application with Provincial Court, there is a $100 filing fee for claims that are $7,500 or less, or a $200 filing fee for claims that are $7,500 or more. Filing fees can be waived if applicants are low income. Applications in RTDRS are heard by a Tenancy Dispute Resolution Officer, whereas applications in Provincial Court are heard by a judge. For both dispute resolution methods, decisions can be appealed to the Court of Queen's Bench within 30 days, and any decision issued is considered legally binding. When resolving a dispute through RTDRS or Provincial Court, the following remedies are available under the RTA. For tenants, this includes damages, rent abatement, compensation, and termination of tenancy. For landlords, this includes recovery of rent, termination of tenancy, recovery of property, and damages. If a tenant or landlord is being sued, they must attend the hearing or risk a decision being made against them. Tenants and landlords should seek legal advice as soon as possible. For example, they can contact Lawyer Referral Service at 1-800-661-1095. Legal clinics are also available across Alberta for low-income tenants. Don't forget to check out our Laws for Landlords and Tenants in Alberta website. To access all of our publications about renting in Alberta, you can download them for free on our website, or you can contact us to get a printed copy.
Thank you for watching this video from the Centre for Public Legal Education, Alberta. We endeavour to make the law understandable for Albertans. You can find CPLE's resources on our website, cple.ca, or reach us via email at info@cple.ca, or simply by phone at 780-451-8764. Until next time,